Thank you, Madam President. Your Honors. I'm Akila Radhakrishnan, the President of the Global Justice Center, presenting on behalf of the Global Justice Center, Women's Initiatives for Gender Justice, Amnesty International, and Dr. Rosemary Grey. Today, in answering your questions, I will focus on three aspects of forced pregnancy. First, the legal interest behind the crime. Second, some key elements of the crime. And third, the relationship to national laws relating to pregnancy. To the first point, on the legal interest behind the crime. The criminalization of forced pregnancy protects the right of every individual to exercise agency over their body, their fertility, and their sexuality. As such, the legal interests protected by the crime are personal, sexual, and reproductive autonomy, values central to the protection of physical integrity and human dignity, which are at the core of both international human rights and humanitarian law. The protection of reproductive autonomy was the rationale for the inclusion of the crime in the Rome Statute, distinct from related crimes such as rape or unlawful confinement. As noted by the CLRV, when the Women's Caucus for Gender Justice, now the Women's Initiatives for Gender Justice, and Amici here, first proposed that forced pregnancy be recognized as a crime in the Rome Statute, the offense was described in terms of attacks on reproductive integrity. Further, during Rome Statute negotiations, it was proposed that the statute refer to forced impregnation instead of forced pregnancy, but this was rejected. States understood that forced pregnancy involved more than making a person forcibly pregnant. It also involved restricting the victim's ability to decide whether and under what conditions to proceed with that pregnancy. Your Honors, this distinct legal interest is aptly expressed by the trial chamber phrase, personal and reproductive autonomy, a concept now widely embedded in international human rights law. We are not alone in supporting this interpretation by the trial chamber. The prosecutor and both victims' legal representatives agree. There are suggestions that the concept of reproductive autonomy is too political to discuss in this court, or should be viewed in light of cultural considerations. But such political and cultural considerations are irrelevant in this court. Further, the notion enjoys substantial support. As our brief demonstrated, international and regional instruments explicitly protect these rights as recognized by a range of human rights mechanisms and courts. In addition, the majority of countries allow access to abortion, particularly in the context of rape. For these reasons, reproductive autonomy is the appropriate legal interest behind the crime of forced pregnancy. I will now turn...
Please slow down again. I have another message from the interpreters.
I will now turn to the second point of our submission today, the elements of forced pregnancy. I'm going to focus on just two, noting that all parties agree that the trial chamber correctly identified the legal elements of the crime. Let me start by addressing the definition of unlawful confinement. Confinement is unlawful when it violates domestic or international law or procedure. We note, Your Honors, that the Rome Statute does not define the term confinement. In accordance with Article 21(3), confinement must include all violations of the right to liberty in international human rights law, which, according to the Human Rights Committee, concerns freedom from confinement of the body. This human rights analysis indicates that confinement should not be understood narrowly to require internment under lock and key, but as restrictions that, in practice, mean a person cannot leave. The ICTY Kunarat's case is helpful here. There, the trial chamber held that women had been held captive in a house even though they may have had a key because they had nowhere to go. They were surrounded by enemy territory. They had no place to hide. A person is deprived of their liberty even though they are theoretically able to leave the place of confinement if they cannot go anywhere. We submit that this analysis gives proper meaning to the right to liberty and can guide this chamber's interpretation of the term confinement. The drafting history of the elements of crimes also show that states rejected a proposal to require imprisonment within a confined area for forced pregnancy, preferring to leave the term to be decided on the facts of the case. I now turn to the specific intent for forced pregnancy. The trial chamber correctly found on the facts that the specific intent to carry out other grave violations of international law had been met. It held that there was intent to continue committing certain Rome Statute crimes. We submit, and the prosecutor agrees, that the phrase other grave violations of international law is not limited to Rome Statute crimes. It must include, in line with Article 21.3, serious violations of internationally recognized human rights, including the rights to life, to be free from torture or other forms of cruel, inhuman, or degrading treatment, and to be free from discrimination on the basis of sex or gender. In that respect, given the precedential nature of this case, we believe it would be useful for the appeals chamber to express its views on the intended scope of the phrase, other grave violations of international law. I will now turn to the issue of the relevance of national abortion laws. The second sentence in Article 7.2f states that the definition of forced pregnancy shall not in any way be interpreted
Please, again,
as
go a
affecting
little bit slowly.
national
Thank you.
laws relating to pregnancy. This sentence is merely stating the obvious. The ICC has no authority to directly amend, nullify, or void national legislation. The purpose of this sentence was not to add a new element to the crime, nor was it to restrict the ICC's interpretation. Rather, as has been said today, its sole purpose was to confirm that including forced pregnancy in the Rome Statute does not, in itself, invalidate national abortion restrictions. This position seems to be shared by the defense, who claim in its appeals brief that the trial chamber failed to inquire about the effect its interpretation would have on the national law of Uganda on abortion. This claim raises a question as to if the ICC should modify its interpretation of the legal elements of a crime depending on the content of a national law. The answer is clearly no. Interpreting the definition of forced pregnancy as being contingent on national abortion laws is erroneous. It is at odds with the drafting history, would lead to legal uncertainty, and would result in discriminatory outcomes in violation of Article 21.3. First, the relationship between national abortion laws and forced pregnancy was the subject of extensive debate at the Rome Conference, as the prosecutor and the CLRB have detailed today. As correctly noted by the trial chamber, the final sentence in Article 7.2f resolved this debate by allaying the concern that criminalizing forced pregnancy may be seen as legalizing abortion. Second, adopting the defense's approach would also lead to legal uncertainty. Your Honors, it cannot be that an international crime has a chameleon character whereby its interpretation is influenced by the national laws of the state in which that crime occurred.
You have 1 minute remaining.
The outcome would be impractical, lead to unequal protection for victims, and legal uncertainty for prospective defendants. We additionally submit that Article 7.2f cannot be interpreted as exempting criminal liability under the Rome Statute to those who perpetrate forced pregnancy pursuant to national laws. Indeed, it is a fundamental principle provided in Nuremberg Principle 2 that although an act may be legal under national law, this does not relieve individual criminal responsibility under international law. The second sentence of Article 72F has been given
Please,
its
you have 30 seconds to conclude.
has been given its proper meaning in this case. The ICC's interpretation of forced pregnancy has no direct impact on the national laws of a state, here, Uganda, and conversely, the national laws of a state do not impact the ICC's interpretation of that crime. Thank you.
Thank you.